Hi, friends. Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Here's what we're discussing today. So yesterday, I think we established pretty clearly that Nicholas LaFleur, the police officer that was the first of the state's witnesses, was not exactly the most inspiring, articulate, well-spoken person who's ever testified in a courtroom. And I think it was also fairly clear that almost nothing he was saying at the time was anything that hurt Alec Baldwin. The issue with a witness is that you always want to get as much as you can from them, and then you know that they're going to get beaten up on cross-examination. So hopefully you've prepared them for that. And I'm going to point out a few things here where it looks like he wasn't really well prepared for his cross-examination, and I'll explain why. And then the other thing we're going to look at is what the goal of the defense attorney is at this point while he's doing all of this questioning of Mr. LaFleur. With that in mind, let me give you a little more information about Alex Spiro, who is representing Mr. Baldwin. Here is Mr. Spiro's page from the Quinn Emanuel Law Firm website. It says he is a partner in the firm's New York office where he serves as a co-chair of the Investigations, Government Enforcement, and White-Collar Defense Practice. He's a graduate of Harvard Law School, yippee-ki-yay. As the Manhattan prosecutor, among other cases, Mr. Spiro helped indict and convict Rodney Alcala, the dating game serial killer, for 2 New York murders in the 1970s. Okay, so he has some experience prosecuting cases. As lead counsel, he's tried over 50 cases to verdict. Notably, over the last several years, he's secured a string of verdicts for his clients in both federal and state court. His area of practice spans nearly every type of litigation or dispute across the globe. First Amendment law, securities. He's also overseen an array of complex investigations, serves on the faculty of Harvard's Trial Advocacy Program, lectures at Harvard Law, and has lectured on a variety of subjects including trial practice, corporate privilege, and those sorts of things. Prior to becoming law, he studied biopsychology and worked at Harvard's psychiatric facility, McLean Hospital. In his 5 years at McLean, he supervised departments of adolescent treatment facilities that ran a program for children with autism and Asperger's syndrome. So he has an interesting mix of experience. But I think the thing that really stands out to me is his background in psychology. Because much of what a trial lawyer does, particularly in a case like this, is related distinctly to psychology. And it relates to how the jury perceives information, how it processes information, and how some forms of persuasion are more effective than other forms of persuasion. So let's look at his cross-examination of the police officer and talk a little bit more about some of the things that he's doing here.
May I proceed?
Sorry, Mr. Spiro.
Oh, sorry.
Get that out of your way.
It's always fine when the court interrupts me.
It may seem like a small thing, but what you see there is Mr. Spiro playing to the judge. May I proceed? And, of course, he doesn't really need to ask that because she's past the witness, right? But he asks, and then he smiles up at the judge and says, whatever the court wants. I often tell people that, the number one rule of trial practice is don't honk off the judge. And he's making sure he doesn't honk off the judge here. And you will notice throughout this examination that most of the rulings on these objections are going his way. And that could be because he's being pleasant, he's being professional, and he's not, engaging in a lot of hijinks, at least not openly.
When you got to the scene, Mr. Baldwin walked up to you and said, I was holding a gun. He blurted it out, right?
Yes.
And in fact, he was very shocked, if you could picture Alec Baldwin in a pale state, very unsure of himself. You could say an actor out of character. Fair?
Sure.
Object to the former question. It is Mr. Spiro testifying in the question. Okay.
May we approach?
Did you catch that? Oh, it's all so unnecessary, Judge. This woman's just, she's making hay over nothing. We're supposed to testify. I mean, that's essentially the art of cross-examination. You testify through the witness. And I'm sure that's what he's saying at the sidebar.
When you saw Mr. Baldwin, he looked very shocked. If you could picture Mr. Baldwin in a pale state, like unsure of himself, you could say an actor out of character. Is that a fair description?
Sure.
And he said to you, I'm here, whatever you want to do, right?
Yes.
He said to you at one point, where should I go? Right?
Yes.
And he also pointed out to you who the director was on scene who was hit in the shoulder, right?
I believe so. Yes. I inquired about him.
And he also asked you how she was doing, right? Meaning Miss Hutchins, right?
Yes.
I don't remember you being asked about that on direct, were you?
And you mean masked by the state?
Yeah.
Objection relevance? Overruled.
So I want to take a step back. The dispatch that came over to your radio, sir, before you got to the scene was a dispatch for an accidental shooting by a prop gun, correct?
I believe that's what was told to me, yes.
Okay. And you've testified to that previously, right?
Yes.
Okay. And the dispatch report, you know that you received that wording, accidental discharge, several times, right?
I believe so.
Okay. So I want to ask you, how come when you described it today in court, how come you didn't include the word accident when you testified before this jury?
A couple of things here. First of all, you may have noticed that what Baldwin said was, I was holding the gun. He didn't say, I shot the woman. He said, I was holding the gun, as if the gun acted on its own, which we know the Pietta revolver wouldn't do. So we know that the whole theme of their case is this is just a tragic accident. And of course, if it's a tragic accident, why, it must not be anybody's fault. But of course, the entire legal system, at least the civil trial system, is arranged around the whole idea that people can be at fault and can be negligent even when there's an accident. When there's an accident, usually it is somebody else's fault, and that's the whole purpose of litigation. So now what's happened is he's talking about an accident. Why didn't you say that it was an accident? Why wasn't it an accidental discharge from a prop gun? Because it was actually a real shooting from an actual gun. But see, what he's trying to do at this point is introduce into the narrative this idea that it wasn't intentional, which is another giant red herring. In other words, he's setting up a straw man that he can easily knock down. How do we know he can knock it down? Because Baldwin is charged with involuntary manslaughter. Involuntary manslaughter is essentially criminal negligence, gross negligence. And as a result, there is absolutely nothing whatsoever to do with intention or intentionality. But he's introducing this into the narrative. You'll notice the state didn't introduce it into the narrative. The reason they didn't ask him about the accident is because it's pretty clear from the entirety of that video that he came there because of an accidental shooting. The state doesn't dispute the fact that it's an accidental shooting. They dispute the fact that the guy wasn't negligent, because that's essentially where they're going. But he's setting up this straw man so that he can argue, well, there's just no crime here because there's no intentionality. But again, that's not an element of the crime. So hopefully what will happen here is the prosecutor, when she goes to argue this case, will talk about how the defense was consistently throwing up red herrings. And I have to assume that's the only reason that she's not vociferously objecting to this issue of intentionality as he's bringing it up right now.
I'm not one to say if it was an accident or not. Just there to initially respond to it, and then the detectives determine whether or not it was an accident.
Well, sure, but every other time you've been asked about this, you've said it was an accident. And now today at the trial of Alec Baldwin, when you're talking to this jury, you left that word out. Isn't that true?
Not intentionally, no.
Did you meet with the prosecutors before you testified here today?
Just briefly in the room outside. For them to tell me who was in order of what witness.
You've discussed your testimony previously with Miss Morrissey, correct? Before today?
Just in a pretrial interview, yes.
And now what he's doing is he's trying to make it look like the prosecution told you not to say anything about the accident, right? Except why would they do that? They know this is an accident. That's why they're prosecuting it the way they're prosecuting it. If they thought that Baldwin had done this intentionally, they would have prosecuted it in that manner. So this is another trial lawyer trick. Make the guy look bad. Now, he obviously did not conspire with the state to give false testimony here. He simply is responding to the questions that are asked. He doesn't get to control the questions that are asked. He gets to control his answers. And the fact that he didn't say accident every time somebody asked him a question, that's not his fault. And it's also not an indication of him being untruthful.
And one of the things that you do as an officer on the scene is you observe demeanor, right?
Yes.
And you spent 10 hours on the scene, I think I heard you say, right?
Yes.
You got to see the people of Rust that day live, right?
Yes.
And the truth of the matter is that you took it as a way how everybody was acting and that the individual who claimed to have been holding the firearm was still there, that there was the way he was, his demeanor was that there wasn't any intention behind the act, as you could say. Isn't that true?
Now here we have a police officer who doesn't have a lot of experience. He obviously doesn't have a lot of experience testifying in trial. And what he doesn't recognize here, what the witness is not really aware of, even though he probably should be, is that Mr. Spiro is reading from the transcript of his pretrial interview. In other words, or his statement. Maybe it was a statement to the police, but at any rate, he is reading from a statement. He's not telling him that he's reading it from a statement because he doesn't want him to know that. He wants to see if he can make him into a liar. And he's actually fairly close to doing that in this little setup here. So that's what's going on. Pay attention.
I wouldn't say there was no intention. I don't know the individual's intentions, but his demeanor was sad, upset.
Okay, well, it's not just his demeanor being sad and upset, right? Okay, we'll move that to the side. And I understand you're not a mind reader, right? Correct?
Yes.
Okay. All you can do is look at the people and look at how they're interacting and make your own judgments, right?
Yes.
Okay, and you do that as a police officer to try to figure out how to interact with a scene. True?
Yes.
Okay, and isn't it true that the way you took it, how everybody was acting and that the individual who claimed to have been holding the firearm was still there, that there was the way he was, his demeanor was that there wasn't any intention behind the act, as you could say. Isn't that true?
Again, the wording you're using, I wouldn't say I had any clue of whose intention was what, but he was sad and upset.
Okay, well, let's play. I'm going to play his statement to that effect. Can we cue that up, please? If that's okay with the court. He's saying he didn't say that he did. I'm going to impeach him. Well, you want me to clarify that? Yeah. Okay. Are you claiming that you didn't say that?
Rephrase what you said?
Sure. Dispatch said it was an accidental shooting by a prop gun. So I didn't know if there was any. I took it as the way how everybody was acting and that the individual who claimed to have been holding the firearm was still there, that there was the way he was, his demeanor was that there wasn't any intention behind the act, as you could say,
Again, I wouldn't say I knew what his intention was.
I understand that. What I'm asking you now, okay, is did you in fact say those words that I just asked you?
At what time? The Gutierrez or PTI?
Yes.
I may have.
Okay. You don't deny saying that.
No.
Now they break for this sidebar where she's going to raise a number of objections to this continuing inquiry. Hopefully she's raising relevance objections here, and the judge should know better than really to allow this in because it's complete nonsense. It's a red herring. There is no issue of intentionality. That's not an element that the state has to prove or even wants to prove. So hopefully she's raising this because the cross-examination here has no effect other than to potentially confuse the jury. But here's the interesting part about that. In some respects, I understand why she let it go on as long as she did, and why she's only objecting now when she's trying to prevent this from occurring, because the guy didn't tell him that it was a statement that he was reading from. He just started spontaneously spouting all of this stuff. And the reason that she probably let this go on up to this point is because now she has to keep him from being impeached, because he did say that in his pretrial interview. He did say that in his interview about intentionality, but again, that has no place in the case. So what she's doing now is she's trying to prevent him from getting hamstrung like this, and it looks like Spiro went on from that point in time. But let me explain to you why she let it go on, if she's smart. If she's smart, what she will probably do in closing argument is say, do you remember when at the very beginning of this case, the very first witness, Mr. Spiro had lots of words to say about it being an intentional act. He kept saying it wasn't intentional, it wasn't intentional. And you remember how he beat up on the policeman without even telling him that he was reading from his statement. And you may recall, that was pretty confusing for the officer. But here's the problem, ladies and gentlemen. If you look at your jury instructions, you won't find the word intentional anywhere in there, because intentional acts are not part of a gross negligence claim. The only thing that's at issue in a gross negligence claim is the negligence of the defendant. And in all of that nonsense about being intentional or non-intentional, or accident or non-accident, none of it has any bearing on what you have to find as jurors in order to convict Alec Baldwin. And as a result, I think that would be a very, very effective way to sort of deal with this approach. Now, you have to remember that Alex Spiro is from New York, and New Yorkers tend to think that that's the be-all and end-all of law. They don't understand how people in what they call flyover country think. If you've got a jury of New Mexicans, and a lot of them have handled firearms, a lot of them understand the rules of gun safety, and a lot of them are probably not really buying into this whole theory of, it was a cosmic ray that caused this to happen, or, maybe the magnetism at the Earth's poles changed somehow and set off the trigger. They're not buying into any of that, hopefully. What they're doing is they're trying to listen to the evidence and figure out what in the world this guy is saying. And so, on closing argument, you'll have an opportunity to slap him silly about this whole idea of it being intentional or unintentional. Because again, unintentionality is not an issue in the case. So that's what I have for you today. I don't want to go on too long here because there really isn't a whole lot more you can get out of Mr. LaFleur. And there are other things that we can cover in this trial. But this shows you a big difference between the prosecution and the defense. The defense, they have one goal, and that's it. A confused mind always says no. If you bamboozle the jury and point this way and that way and, oh, look under the rug, oh, look on the ceiling. At the end of the day, they're like, what? I don't even understand where he was going. But, obviously he's pointing all this out. It must be important. Well, no, it's not important. The whole idea is to confuse, distract, deny, and defend. And that's exactly what Mr. Spiro is doing. If you would, like this video. That tells YouTube that it's valuable and that other people should be watching it. If you haven't already, I would appreciate it if you've subscribed. If you have any comments, drop them down in the comment field. Or if you want to, you can email me at the address above. Thank you so much for watching. If you have the opportunity today, please go out of your way, do something kind for someone. It doesn't matter if it's a big kindness, like writing somebody a check, helping out at the homeless shelter, whatever it is. If you just try to do one kind thing a day, we can all make the world a better place for everyone in it. And that's got to be a good thing, right? After you've done something nice for somebody, come on back down here tomorrow, join me at the beach, and we'll talk about something else fun. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.